Hello, ladies and gentlemen. Welcome to American Spirits, episode 22. As you can tell by the title and by the thumbnail, we're taking a break from our series on interventionism and the American ethos behind that set of policies and the history behind it. Instead, today we're looking at Oliver Wendell Holmes's The Common Law. I am joined by Mr. Quinn. How are you doing, sir?
I am very well, and now for something completely different.
Yes, yes, exactly. We're in an intermission, or something similar. Uh,
Indeed, the fact that your co-host has decided to treasonously counter-stream us, we decided to get off the track and go down a little bit of a digression.
yeah, that's true. We should if only we had a procedure for handling such disputes as these treasonous treasonous actions. Maybe
Sadly, the only procedure is personal vengeance.
yes, quite. And in fact, we're about to talk about that. The only method that we can solve this with is by blood feud, right?
That is the state of things, approximately 600 AD. Yes.
Perfect. I mean, it's not much more to innovate upon there. But regardless, regardless of our treasonous counter-streaming strife here, um, I will be somewhat a commenter this stream. Mr. Quinn will very much be doing the heavy lifting, and we're going to be talking about. I think we were talking about in the before the stream went live. Uh, Oliver Wendell Holmes, the future from the perspective of the work that we're reading, Supreme Court Chief Justice, was the main progressive that got the Supreme Court to adapt to the progressive movement in the country, which completely changed how I don't know if I want to say how the legal system worked, but certainly a lot of the philosophy behind the laws. A lot of new things were entered in. Things were completely reinterpreted. We'll talk about a lot of that today. But Mr. Quinn, do you have any more background for us there?
Yeah, certainly. So when we talk about the common law, we're specifically in the context of American spirits talking about Anglo-American law. And it may surprise the audience to learn that Anglo-American law is about 2,000 years old. It is the product of the marriage of Roman law with German tribal law, mixed in with a bit of Celtic law, and then vigorously shaken for 2,000 years, transplanted onto this continent, and then further developed from that point. So Mr. Holmes is going to take us through a historical survey of the development of the common law and how it has evolved up to his point. He's speaking in 1881, and then he'll make some prescriptions for how it should evolve looking forward from 1881. And with the benefit of 140 years of hindsight, maybe we'll have some comments to offer on how that worked out. But it's important to realize that the world we live in today, legally speaking, very much is Oliver Wendell Holmes's world. He is probably the most influential jurist in American history, certainly in the 19th century and 20th century. And he is very much the titan who overshadows modern legal thinking today. This work, The Common Law, is going to be read at least in part by every law student, and every lawyer practicing today has had some interaction with this work and the arguments propounded therein.
And
A meta point of
just
interest.
here,
No, so
real quick
please.
as well, just to buttress that point. It's my recollection that besides John Marshall, Oliver Wendell Holmes is the only Chief Justice of the court that like high school students are sometimes or even usually required to read. So so important that it's even taught on the high school level.
Indeed, and a meta point for our project here at American Spirits is to note that Holmes was a Boston man of Unitarian background who in adulthood became an agnostic. And so he is very much representative of the Puritan strain of the American nation in the mid 19th century. We talked at the beginning of American Spirits a great deal about the Puritans in the 17th and 18th centuries. We ventured the point that they had virtues as well as vices, and that their virtues were correctives for their vices, and that this wove into the strand of the larger American nation to make the entire nation stronger. Now we fast forward to the late 19th century, and Mr. Holmes offers us a peek into where Puritan thought and Puritan culture was at this point in American history, and we can draw what lessons we draw from how we find that to be.
Right, and this is also important as well because one of our least watched streams, but certainly one of my favorites was the flowering of of New England, which I think it was me, Charlemagne, and another guest of ours, where we were talking about the influx of foreign thought into New England, basically the actual Puritans themselves that had the actual belief behind the system of laws that they had established had gone out of style, and at the start of the Republic were replaced by Unitarians, who tended to be much more open and tolerant, liberal, even if you want to use a charged word. So the Oliver Wendell Holmes is going to be one of the most important, one of perhaps the most important New Englander in terms of the modern U.S. legal system, and that he had a Unitarian background, I think, is very. It tells a story of New England. He has the Puritan folkway certainly, but the Puritanism has long since changed or been done away with. Something to
Indeed.
lament, maybe.
All right. Well, rather than starting with a preview or a preview of what Mr. Holmes is going to argue and what we might think of it, let's jump right into it and hear from the man himself. This is near the beginning of the first. Oh, I should state that the Common Law is a series of 12 lectures covering different subjects of law throughout the history of Anglo-American jurisprudence. And the first lecture, we're only going to cover the first 3 today because we'd be here for 9 hours if we covered all 12. But the first lecture is the early forms of liability, and this is where we get all the meaty analysis of Roman law, German tribal law, and how that would develop into American law. But towards the beginning, he lays out here what his fundamental theory of law is and what he's attempting to accomplish in putting forward these lectures. And so I shall read, "The life of the law has not been logic. It has been experience, the felt necessities of the time, the prevalent moral and political theories, the intuitions of public policy, avowed or unconscious, even the prejudices which judges share with their fellow men, have had a good deal more to do than the syllogism in determining the rules by which men should be governed. The law embodies the story of a nation's development through many centuries, and it cannot be dealt with as if it contained only axioms and corollaries of a book of mathematics. In order to know what it is, we must know what it has been and what it tends to become. We must alternately consult history and existing theories of legislation. What we must know, but the most difficult labor will be to understand the combination of the two into new products at every stage. The substance of the law at any given time pretty nearly corresponds, so far as it goes, with what is then understood to be convenient. But its form and machinery and the degree to which it has been able to work out the desired results depends very much upon its past." We'll stop there for a second. Ryan, do you have any thoughts about that?
I strongly dislike Holmes for my history education, in which we read him, I think, during his tenure during World War One. So it's no surprise to me that I strongly disagree with this for quite a few reasons. First and foremost is that if we are devolving the law into just experience and not actual logic, if we're trying to demean or sideline the role of logic, we have no. The only explanation that we can have for what the law is, where does it come from, what are the limits that upon people's actions, is a purely naturalistic one. It's only what we can observe in nature, and that's just because fields like metaphysics, which we typically draw upon, especially us people who are not agnostic Unitarians, to deduce what should the law be, would technically fall under something like logic. It's not observed, it's ideal, it has all these more abstract qualities, if you will.
Would you? No,
Yes.
please go ahead.
Well, I was just going to say, so it's not it's not a surprise then that I would strongly disagree with this line of thinking that the law is just experience and history and what we've observed.
Well, it's more than experience in history, it's convenience and expedience.
Well,
What
that was
Holmes,
so that was what I was about to get to, but yes, please
so,
elaborate.
what Holmes is fundamentally doing here, right at the outset, is abandoning any notion of natural law. Historically, Holmes utterly rejected natural law theory, and we're seeing the first indication of it here. Laws are not eternal. Laws do not stem from a deity. They do not stem from any fixed metaphysical principle. They are rather things of their time, in their time, which can be altered to fit the convenience and expedience of the community.
So this is actually interesting. He opens up immediately by saying that the law has been formed based off the convenience of like the present experience, if you will, as well as the past. But I want to focus on the convenience part, because we're going to talk about. He's going to say that the system of laws that we have has. He makes a point later in this lecture, I think just a couple of paragraphs later. The system of laws that we have is not something that can just be assumed to always come about. We can't just take it for granted. It was a long and strenuous fight to maintain it. But here
Indeed.
we're actually told that it came about due to the convenience, the easiest option at a given point in time. I don't I don't get this. It would seem contradictory to me on a first reading, but this is, like I said, slightly outside of my usual field.
Well, that tension is going to raise its head again and again as we go through the lectures here. But to begin with, Holmes will then begin to treat the historical bases for liability in law. Liability is the concept that a wrongdoer or a person who has violated the law must, in some sense, pay for that violation. And so Holmes goes on, it is commonly known that the early forms of legal procedure were grounded in vengeance. Modern writers have thought that Roman law started from the blood feud, and all authorities agree that German law began in that way. The feud led to the composition. This is a legal term for a particular kind of legal action. At first optional, then compulsory, by which the feud was bought off. The gradual encroachment of the composition may be traced in the Anglo-Saxon laws, and the feud was pretty well broken up, though not extinguished, by the time of William the Conqueror, which is 1066 for those keeping track. The killings and house burnings of an earlier day became the appeals of mayhem and arson. Appeals de pace et plagis and of mayhem became, or rather were in substance, the action of trespass, which is still familiar to lawyers. But as the compensation recovered in the appeal was the alternative of vengeance, we might expect to find its scope limited to the scope of vengeance. Vengeance imports a feeling of blame and an opinion, however distorted by passion, that a wrong has been done. It can hardly go very far beyond the case of a harm intentionally inflicted. Even a dog distinguishes between being stumbled over and being kicked. So here Holmes is setting us up for later discussions. He's bringing up this idea of harm and this idea of vengeance. Holmes's thesis is that basically all law of criminal and tort is a law of vengeance for wrongs, and inherent in the concept of a wrong is a concept of blame. And Holmes will spend a lot of time discussing how blame is to be assigned. But Ryan, as far as we go here, do you have anything to say?
Well, I do find it interesting because if you read, say, a theologian on this topic from a few centuries ago or something similar, there is a very clear idea of someone being wronged and someone that would have to in some way perform restitution. But this is the way that is derived compared to what we just heard is very different. Reading this from Holmes after, like I said, having read, say, a theologian or a natural law, someone that believes in natural law, this comes across as very contrived. It's all about perception. I perceive that I have been harmed, and other people might be able to corroborate on that, despite the emotions that are flying around, clouding my perception and judgment. Whereas like I said, the system that I'm used to reading about, it's very clear you have things that are wrong, provided provided these criteria are met, or something similar. This feels different. I'll put it that way.
It's interesting. I'll continue. The cause of action in the cases of trespass, reported in the earlier books and in the Abbreviatio Platorium, is always an intentional wrong. So let me break off right there just to explain to the non-lawyers in the audience. When he's talking about books and these various Latin documents, he's talking about reports of court cases. Anyone who may have had studied law prior to 2010 will be familiar with the fact that every case that is ever decided eventually ends up in a book on a shelf in a law library. There are, huge volumes of huge collections of many thousands of volumes describing all the court cases in the state of Georgia, all the court cases in the state of Maryland, all the court cases in the United States federal courts. And this is true of England as well. You can go into English law libraries and American law libraries and look up books of cases that were decided in the 12 and 1300s. And as Holmes is conducting this historical survey of the common law, that is what he's relying on. He's looking at old court cases, in this case early on, very, very old court cases from the time of even Alfred the Great, which I believe puts us in the 700s. So that's how far back these court cases are being decided, and this is the material he's consulting as a historian, and that lawyers to this day consult as part of their profession. In fact, any English case decided prior to 1776 is still technically good and binding law in the United States. One of the first things the states did after independence was they adopted various laws stating that all precedents prior to the Revolution were still good, so that the American courts would not have to start from scratch. Anyway, I'll continue. The cause of action in the cases of trespass reported in the earlier books is always an intentional wrong. It was only at a later day and after argument that trespass was so extended as to embrace harms which were foreseen, but which were not the intended consequence of the defendant's act. Thence again, it was extended to unforeseen injuries. So here he's telling us about the very earliest beginnings of what we now talk about as negligence. This idea that you can be held liable for harms that you cause, even if you didn't mean to cause harm, if your actions were sufficiently dangerous that it was foreseeable that they would cause harm, according to standards which we'll discuss when we get there. Now, this is the first germs of that idea that you didn't have to mean to hurt someone to have to compensate them for harms that you've done. Moving on, a very common phenomenon, and one very familiar to the student of history, is this: the customs, beliefs, or needs of a primitive time establish a rule or formula. In the course of the centuries, the custom, belief, or necessity disappears, but the rule remains. The reason which gave rise to the rule has been forgotten, and ingenious minds set themselves to inquire how it is to be accounted for. Some ground of policy is thought of, which seems to explain it and to reconcile it with the present state of things. Then the rule adapts itself to the new reasons which have been found for it, and it enters on a new career. The old form receives new content, and in time, even the form itself modifies to fit the meaning which it has received. So here we have the great statement against formalism. Holmes says the old customs and old beliefs create forms of law, and then everyone forgets what those forms meant. The reasons for the forms disappear, and so since they don't want to get rid of the forms for silly sentimental reasons, they think up whole new reasons and jam them into the old forms, which then changes the old forms into new forms. So this is essentially a rejection of Chesterton's fence.
Yeah, right, and that's the thing that should come to mind most prominently. This is a very fascinating line of reasoning. I guess they were contemporaneous, but I doubt they would have been reading each other, certainly. I find it very strange that you can, in parallel development, find Holmes here talking about basically the exact same thing that Chesterton will be talking about in roughly the same decades, Chesterton died in the 1930s as well. So, however, Holmes here is saying that you basically have to completely rework the fence or the fence post so that it does something completely different because you've forgotten why it's there, and it doesn't matter.
The
And
fence post
which,
must be made to evolve.
yeah, right. And this is a I don't want to, or rather, I'm sure you can elaborate upon this, but this is a common theme that I got when I was reading through it, and it matches the other things that I know about Holmes. Um, we have this idea, basically, that human civilization, I don't want to say nature necessarily, but certainly human civilization changes. It progresses, obviously. That's the political movement that he was a part of. But specifically, we have this idea that we can outgrow things that were made for simpler peoples and civilizations, which, for as ingenious as he's made himself out to be, trying to inquire why it is that we have these older forms, um, you would think he would give a little bit more credit to why they were there in the first place. You'd think.
You'd think, but he's more focused on why we need to discard them and move on to new forms consciously and more speedily, which we'll see as we move on. Now, from this point, Holmes gives us a series of examples, and these are pretty classic law school examples of old forms of law that have persisted to his current day, and in many cases to our current day. So let's look at some of these examples. One, a man has an animal of known ferocious habits, which escapes and does his neighbor damage. He can prove that the animal escaped through no negligence of his, but he is held liable. Why? It is, says the analytical jurist, because although he was not negligent at the moment of escape, he was guilty of remote heedlessness or negligence or fault in having such a creature at all, and by one whose fault damage is done ought to pay for it. So that seems fairly reasonable. He has an animal that he knows to be ferocious. He keeps it anyway, and even if he had a really good cage on it, it somehow got out. But having the animal in the first place was so blameworthy that he is made to pay for the damage done by it after it escapes. Any problems with that, Ryan?
Perhaps I'm being very simple-minded here, but I don't know why one couldn't just make the argument that he owns the animal and it caused harm, therefore he should be required to. I don't know. Maybe I'm not seeing a very obvious counter to that, but I don't disagree with the conclusion, certainly.
Well, it's interesting the way you pose that question, because the way you pose it sets it up as a case of strict liability. He owns the animal did harm, therefore he has to pay for it. That's what is called in law strict liability. Holmes here is doing something a little bit different. He is introducing, at this point, just tacitly, this idea of negligence. He's saying that owning the animal in the first place, it's not the mere fact he owned the animal is why he has to pay, but the fact he knew it was dangerous and owned it anyway, that he has to pay. You see the distinction?
Yes, I do see, and that's kind of why I was trying to provide a differing reasons, because I do not like that line in particular.
Well, let's try this one.
Yeah.
A baker's man, while driving his master's cart to deliver hot rolls of a morning, runs another man down. The master has to pay for it, and when he is asked why he should have to pay for the wrongful act of an independent and responsible being, he has answered, from the time of Ulpian to that of Austin, Ulpian being an ancient Roman jurist and Austin being a more recent English jurist, that it is because he was to blame for employing an improper person. If he answers that he used the greatest possible care in choosing his driver, he is told that is no excuse, and then perhaps the reason is shifted, and it is said that there ought to be a remedy against some who can pay the damages, or that such wrongful acts by ordinary human laws are likely to happen in the course of service are imputable to the service. So here, Holmes is illustrating the shift. He's identified two independent reasons one could have for making the baker pay for his driver's running another man down. The first reason is, well, the baker hired a bad driver, and so by hiring a bad driver, he incurs responsibility for what the driver does. And then when the baker comes back and says that I used utmost care to hire a good driver, and this just happened, then the reasoning shifts, and it's that, well, someone has to pay for this guy, and as between the driver and the driver who presumably doesn't have the money to pay, and the baker who presumably does have the money to pay, the baker should pay.
Yes, and this does sound very familiar, especially with the exposure to business law that I had.
Yeah,
So,
this is the beginnings of what's now called agency law, and
yes.
it's very much the case now that except in very exceptional circumstances, an employer is going to have to pay for any torts that his employee commits while in the course of his work. All right, then there's another example Holmes gives. Next, take a case where a limit has been set to liability which had been previously unlimited. In 1851, Congress passed a law, which is still in force, and which by the owners of ships, in all the more common cases of maritime laws, can surrender the vessel and her freight then pending to the losers. And it is provided that, thereupon, further proceedings against the owners shall cease. The legislators to whom we owe this act argued that, if a merchant embark a portion of his property upon a hazardous venture, it is reasonable that his stake should be confined to that which he puts at risk, a principle similar to that which corporations have been so largely created in America during the last 50 years. So this is interesting that he brings corporations into this argument, because a corporation, by its nature, is an artificial limitation of liability afforded by the state upon a businessman. If you own a corporation, only the corporation's assets are at risk, either for debts or for injuries that the corporation might do. Generally, there is no remedy against a shareholder in a corporation. The remedy is only against the corporation. And at the times Holmes is writing this, that's still a relatively novel concept. But either way, the case is, in certain cases, the state will limit liability for its own reasons to the amount which the risquor has actually put at risk by consent, by either buying a share or buying a ship, rather than his whole fortune.
Right. I don't have as much to comment now. I think that
Holmes is just describing examples
yeah.
of how the law works here, so there's no argument being made. Moving on, whatever may be the true explanation of surrender in connection with contracts, for the present purpose we need not go further than the common case of noxo delitio for wrongs. Neither is this seeming adhesion of liability to the very body of the harm of the first importance. Roman law dealt mainly with living creatures, with animals and slaves. If a man was run over, it did not surrender the wagon which crushed him, but the ox which drew the wagon. Here he's referring to the Roman law that, as it sounds like, if you get run over by a cart, your compensation is you get the ox which was drawing the cart. In this stage, the notion is easy to understand. The desire for vengeance may be felt as strongly against the slave as against the freeman, and it is not without example nowadays that a like passion should be felt against an animal. The surrender of the slave or beast empowered the injured party to do his will upon them. Payment by the owner was merely a privilege in case he wanted to buy the vengeance off. So what he's talking about here is, in ancient law, if you were injured by some instrumentality, be it a slave or an axe in the case of Greek law, or an ox or what have you, the remedy generally was either, if a freedman was injured by a slave, the freedman was given the slave to do with as he will. If someone was injured by an animal, they were given the animal to do what they will. And the owner, if he wanted to keep the slave or the animal, could offer money instead, but he didn't have to. He could just give up the instrument of the injury. Moving forward in time, Holmes then says, the law as to ship owners and innkeepers introduced another and more startling innovation. It made them responsible for when those whom they employed were free, as well as when they were slaves. For the first time, one man was made answerable for the wrongs of another, who was also answerable himself, and who had standing before the law. This was a great change from the bare permission to ransom one slave as a privilege. But here we have the whole history of the whole modern doctrine of master and servant, and principal and agent. All servants now, as free, are now as free and as liable to suit as their masters. Yet, the principle introduced on special grounds in a special case when servants were slaves is now the general law of this country and England, and under it men daily have to pay large sums for other people's acts, in which they had no part and for which they are in no sense to blame. And to this day, the reason offered by the Roman jurists for an exceptional rule is made to justify this universal and unlimited responsibility. So that's where Holmes was going with this whole digression into examples. This law of the master being liable for the acts of the slave was a special case that developed in a time when slavery was common, a time not that remote from Holmes's own time in the case of the American South, but which had expanded to become a more general rule of anyone who's working for anyone else can bind their master in liability if they cause harm to someone. So this is an example Holmes would give of the form changing its content and then changing its form.
Right, and this makes sense. This feels like it's so far what he has described is a good chunk of just the common law itself. Is that it originated? It's something with a completely different context, and what we have now is somewhat different. I feel like we are about to get to the perhaps a more objectionable part with what he does with this information.
Indeed, it's very objectable. He's going to start speaking about the Germans.
Well, let's
In
hear
short, yeah, Holmes continues. So to this point, he's been surveying ancient Roman and Greek law. He also discusses the Old Testament to some extent. And now he shifts to the other feed branch of American law, which is German tribal law. And here he says, in short, so far as I am able to trace the order of development in the customs of the German tribes, it seems to have been entirely similar to that which we already followed in the growth of Roman law. The earlier liability for slaves and animals was mainly confined to surrender. The later became personal, as at Rome. The reader may begin to ask for the proof that all this has any bearing on our law of today. So far as concerns the influence of Roman law upon our own, especially the Roman law of master and servant, the evidence of it is to be found in every book which has been written for the last 500 years. It has been stated already that we still repeat the reasoning of the Roman lawyers, empty as it is, to the present day.
I mean, what could Roman lawyers have ever known?
Yeah, indeed. But yeah, he does tip his hand a little bit there, but he'll go on more. But first, back to England. In the Kentish laws of Hochlare and Erde, AD 680, it is said that if anyone's slave slay a freeman, whoever it be, let the owner pay with 100 shillings, give up the slayer, etc. There are several other similar provisions. In the nearly contemporaneous laws of Ine, the surrender and payment are simple alternatives. So again, he could surrender the slave or he could pay for the damage. If a Wessex slave slay an Englishman, then shall he who owns him deliver him up to the Lord and the kindred, or give 60 shillings for his life. Alfred's laws have a like provision as to cattle. If a neat wound a man, let the neat be delivered up or compounded for, and Alfred, or paid for, in other words. And Alfred, although 200 years later than the first English lawgivers who have been quoted, seems to have gone back to more primitive notions than we find before his time. For the same principle is extended to the case of a tree by which a man is killed. If a man at their common work, one slay another unwillfully, let the tree be given to the kindred, and let them have it off within land of 30 nights, or let him take possession of it who owns the wood. So, just a little context there. We didn't excerpt this paragraph, but Holmes is talking about a case where basically some woodcutters were cutting a tree, and it fell over and killed a guy. And the remedy was give the family the tree.
I mean, that's a fascinating remedy for the loss
Yes.
of a whole person.
Yep. To return to the English, the later laws, from about 100 years after Alfred, down to the collection known as the Laws of Henry I, compiled long after the conquest, increased the lord's liability for his household and make him surety for his men's good conduct. If they can incur a fine to the king and run away, The Lord has to pay it unless he clear himself of complicity. But I cannot say that I find until a later period the unlimited liability of master for servant, which was worked out on the continent, both by the German tribes and at Rome. Whether the principle, when established, was an indigenous growth, or whether it was the last step, or whether the last step was taken under the influence of Roman law, of which Bracton made great use, I cannot say. It is enough to say that the soil was ready for it, and that it took root at an early day. This is all that needs to be said here with regard to the liability of a master for the misdeeds of his servants. So here Holmes is saying this was present in Roman law, it was present in German law, it wasn't really present in early English law, but at some point it showed up, and I'm not sure if it was indigenous or whether it was an import. So.
I do find it interesting so far that the historical excerpts that he's given us very neatly make the case for other theories of the law, which is basically the law developed from either natural or non-personal concepts of justice. They all seem to have developed in almost the exact same way. I do find that fascinating.
You mustn't let your noticing become a problem, Ryan.
I'm just saying, if he's about to tell me that everything I just said is wrong or bad, he's done a bad job at implying it so far.
Well, fortunately, he says, I do not mean that our modern law on this subject is only a survival, and that the only change from primitive notions was to substitute the owner for the offending animal. Although it is probable that the early law was one of the causes which led to the modern doctrine, there has been too much good sense at every stage of our law to adopt any such sweeping consequences as would follow from the wholesale transfer of liability supposed. An owner is not bound at peril to keep his cattle from harming his neighbor's person, and in some of the earliest instances of personal liability, even trespass on a neighbor's land, the ground seems to have been the owner's negligence.
All right, so
Are you reassured?
yeah, that's that is a different a different line of argument. Certainly of one that I was anticipating. I will point out though. Um, Actually, I don't think I will point out yet. Do you have any comments before we move on?
Just that again, he's drawing this. He's laying the foundation for the theory he will expound in lecture 3. That the groundwork, the justification for liability fundamentally comes down to blame, and blame in this case would be the blame attaching to negligence, not to the mere keeping of cattle or the mere trespass on neighbor's land.
Right, and that's this is something that I find interesting. This sort of worming in of negligence, but like I said, I'll save that for whenever we get a little bit clearer of a doctrine on that.
Indeed, but Holmes is impatient with this formalism, and so he has some criticism for the great judges. In other words, those great judges, although of course aware that a ship is no more alive than a mill wheel, thought that not only did the law in fact deal with it as if it were alive, but that it was reasonable that the law should do so. The reader will observe that they do not simply say that it is reasonable on grounds of public policy, as they should, according to Holmes, to sacrifice justice to the owner to security for somebody else, that it is reasonable to deal with the vessel as an offending thing. Whatever the hidden ground of policy may be, their thought still clothes itself in personifying language. So here, Holmes is saying that even though these judges, secretly had great public policy reasons for holding shipholders accountable and mill owners accountable, they still damnably insisted on clothing their reasoning in personifying language of ancient forms.
Right, and I was about to say this is if it is true that we are maybe this is slightly different, but say we're talking about a corporation or something else that's constructed rather than specific persons or whatnot. I feel it maybe it's just my background, but it feels like what we're getting to is maybe we just shouldn't do what most of the law does and provide such benefits to these constructs. But once again, I don't feel like that's the direction that this is going.
No, the opposite. All right, continuing. We have now followed the development of the chief forms of liability in modern law for anything other than immediate and manifest consequences of a man's own acts. We have seen the parallel course of events in two parents, Roman law and the German customs, and in the offspring of those two on English soil with regard to servants, animals, and inanimate things. We have seen a single germ multiplying and branching into products as different from each other as the flower from the root. It hardly remains to ask what the germ was. We have seen that it was the desire of retaliation against the offending thing itself. Undoubtedly, it might be argued that many of the rules stated were derived from a seizure of the offending thing as a security for reparation, at first perhaps outside the law. That explanation, as well as the one offered here, would show that modern views of responsibility had not been yet attained, as the owner of the thing might very well have not been the person at fault, but such as has not been the view of those most competent to judge. A consideration for the earliest instances will show, as might have been expected, that vengeance, not compensation, and vengeance on the offending thing was the original object. The ox in Exodus was to be stoned. The axe in the Athenian law was to be banished. The tree, in Mr. Taylor's instance, was to be chopped to pieces. The slave under all systems was to be surrendered to the relatives of the slain man, that they might do with him what they liked. The deodand was an accursed thing, deodand being a term for an object which is surrendered as an instrument of a crime. The original limitation of liability to surrender, when the owner was before the court, could not be accounted for if it was his liability and not that of his property which was in question, even where, as in some cases, expiation seems to be intended rather than vengeance, the object is equally remote from an extrajudicial distress. So Holmes's thesis here is that liability stems from this drive to vengeance, and that modern theories of liability must accordingly be drawn to satisfy that drive.
Source. This is very interesting.
Exodus, Ryan. Exodus.
Well, I was about to go right to theirs because I could have sworn the whole reason that you would say put an animal to death that has slain a man was because of I don't know, a theological or metaphysical reason surrounding the fact that man was made by God or something like that, but that wouldn't make any sense in Holmes's framework because that's ceding the ground that the law can come from a deity.
Indeed.
Or something similar. So I do find this very interesting that Holmes's only explanation for the ox being stoned in Exodus is just out of a mad animalistic desire for vengeance. And he even has the good graces to tell us that even when we think it's not about vengeance, it actually is. Like,
Ryan, we are civilized men of the 19th century, and so I can understand that you are unable to put your mind into the place of a benighted savage of 1000 BC or 1200 BC, and therefore is unable to comprehend the mad, irrational anger that the people of Israel had towards their oxen.
I mean, clearly that's the reason. When you read Exodus, you come away with the fact that these people are so short-sighted that they only care about the most immediate thing attacking them. There's nothing more grand in that book, maybe that could like change the world as you would understand it. I don't know. This seems like a very tough point to justify that this is all just about vengeance. It's almost like it's trying to psychologize a motive that might not actually exist. That's maybe fitting.
Well, let's see where he goes. The foregoing history, apart from the purposes for which it has been given, well illustrates the paradox of form and substance in the development of the law. In form, its growth is logical. The official theory is that each new decision follows syllogistically from existing precedents. But just as the clavicle in the cat only tells us of the existence of some earlier creature to which a collarbone was useful, Darwinianism detected, precedents survive in the law long after the use they once served is at an end, and the reason for them has been forgotten. The result of following them must often be failure and confusion, merely from a logical point of view.
I mean, is this sort of stepping back from the readings here? Is this actually true? Because I feel like if you went through even the most like original of precedents that were set, there is probably a very practical reason behind them. Hence the reason why you would try to follow the precedent again after it was set. Is this point that he's making here actually correct? Because this isn't something I've practiced before. I have not tried to go back to early precedents and try to see if I can reason out the
Yeah, well,
reason behind it.
this is the difficulty with wrestling with Holmes, because he is a world-class arguer, and he's often very convincing, and it's often only in hindsight that you see the problems. But in this instance, form and substance of the law, inform and growth is logical. Yeah, so remember his distinction between form and substances here. He says the form is evolving syllogistically on precedents, but his point is that that's a cope, that's a fiction, that in fact the substance of the law goes with experience towards expedient ends, and that if the form doesn't follow the substance, then you get things like the clavicle of the cat, which exists for no reason, and this causes failure and confusion from a merely logical point of view.
Sure. Okay. I suppose what I'm really trying to get at here is that this idea that the argument that relying on precedent is a just that, an argument. It's not actually what's happening. I feel like that can only be made if the precedent itself is not very immediately or experientially reasonable, as in if a precedent that was made was so obviously bad, I have a feeling it would in some way change such that not just the form but also the substance would change. I feel like that might be something in the history, no?
Yes, absolutely. The law does this all the time. Precedents sometimes are explicitly overruled by later courts, and more commonly, precedents are distinguished out of existence, which is judges, pay lip service to the old rule, but find excuses in the different facts of the case to not follow the old rule and come up with a new rule. This is bread and butter for the law.
All right, yeah. So maybe we should we should get closer to the culmination of his argument then, because this is all picking at it before he gets to the main point, I feel.
Correct. On the other hand, in substance, the growth of the law is legislative, and in a deeper sense than what the courts declare to have always been the law is in fact new. It is legislative in its grounds. The very considerations which judges most rarely mention, and always with apology, are the secret root from which the law draws all the juices of life. I mean, of course, consideration of what is expedient for the community concerned. Every important principle which is developed by litigation is in fact and at bottom the result of more or less definitely understood views of public policy. Most generally, to be sure, under our practice and traditions, the unconscious result of instinctive preferences and inarticulate convictions, but nonetheless traceable to views of public policy in the last analysis. And as laws administered by able and experienced men who know too much to sacrifice good sense to a syllogism, it will be found that when ancient rules maintain themselves in a way that has been and will be shown in this book, new reasons more fitted to the time have to been found for them, and they gradually receive a new content and at last a new form from the grounds to which they have been transplanted. So maybe you have more to sink your teeth into here.
Oh, plenty. Because I think every single person has had to deal with this argument that what you're really doing is not what you say it is. It's because of an inarticulated and instinctive preference. We have just simply rebranded that idea to a slightly more combative phrase in the modern day, and it burns me every time it's used. This idea that you just have a unstated or even an unconscious bias, if you will, towards something that
Indeed.
like this is when I was reading over this last week in preparation for the stream, I just immediately thought of that here, and was my mood turned very sour. But
All right.
that's the core of the argument. We have this unstateable, instinctive, real motivation that drives our lawmaking. I suppose that's a much
Indeed.
deeper claim than I guess an HR position choice or something like that.
And this hitherto inarticulate and instinctive reason is public policy. And what Holmes means by public policy is this idea that the community has an evolving understanding of its own needs and its own requirements, and that it shapes the law to accord with these needs and requirements, with this public policy, and is just lying when they pretend to be following precedents or exploring a syllogism.
I do find it
And
fascinating.
here,
He has this phrase that we would not surrender our good sense to syllogism, which is
syllogisms are famously in opposition to good sense.
right. I was about to say I'm trying to come up with a different means of good sense that doesn't come from some form of syllogistic reasoning. That's very difficult to do.
Maybe if you were a Unitarian.
Maybe, or maybe if I just let my biases towards the community's goals and public policy take over, maybe then I would know.
Okay, so Holmes has presented us with this view of the law, that the law is merely an inarticulate expression of the unconscious will of the community. And here's where he takes the really revolutionary turn in the next paragraph. But hitherto, this process has been largely unconscious. It is important that, on account, to bring to mind the actual course of events, what the actual course of events has been. If it were only to insist on a more conscious recognition of the legislative function of the courts, as just explained, it would be useful, and as we shall see more clearly further on. Ryan, you've read Article 3 of the Constitution. What legislative function does it give the courts?
None.
Huh.
So this is.
So whatever is he talking about here?
So if one could play devil's advocate, like, isn't that the point of common law, judge-made law?
Well, as Holmes has brought us to understand it, yes, that is the entire point of the common law. That was
or
not
at least the distinction, I suppose, not the point, but
yeah.
the thing that distinguishes it from other forms of law. Like, couldn't someone make that very basic argument?
They can today because the common law is now Holmes's common law. But
got it.
Prior to Holmes, the common law was viewed as a application of the natural law to particular cases. It proceeded from a metaphysical source. Holmes has already abandoned that metaphysical source, and in the previous paragraph, he has regrounded it in the expedience and the convenience of the community, in public policy. And once you unmoor the law to a metaphysical source and you just make it about what the community wants or the community needs, then it is not only the right, but it is the duty of the courts to embrace the role of legislator and to consciously, rather than unconsciously, continue to mold the law to the needs of the community. That is the revolution Holmes has effected in these two paragraphs here.
Right, and this is as you can see by the last, did he resign from the court or did he die on the court? I don't think he was there in 1935.
He was definitely there in the 30s. Let's see.
Oh, okay. I mean, so the last century or so has been a great trial run of this method of legal theory. I mean, do you have any complaints?
I mean, one or two quibbles, perhaps. But I mean, what I think you're driving at is Clark v. Griswold, a very famous case from the 1950s, wherein the court used the famous phrase "emanations and penumbras," even though the right to contraception was not in the Constitution. If you look at the Constitution and the principles it expresses and draw from it these vibes that the Constitution emits, then you can come up with new rules of law better fitted to the times. That's where this culminated, but it begins here with Holmes in 1881 in the common law.
So if you could, for the benefit of the audience, we've had a maybe briefer than we've been with Holmes so far. Not fair to Holmes; he's not trying to be brief. But could you explain to the audience like how reasoning along these lines might have gone? Like, what's the foundation for common law pre-Holmes? What is it supposed to be doing? What is the purpose? Because so far Holmes has been saying that the law originates because we have this drive towards public policy that benefits our community or something similar. This is driven by we say by precedence, but in reality it's by we go on what's convenient. What would be what's the pre-Holmesian explanation of the law before this, if you could provide that?
Sure. So the pre-Holmesian and the pre-modern conception of the law is that the law is a pre-existing eternal thing that men grasp at imperfectly to execute on earth. This is the medieval conception. This is natural law. God has ordered the universe in such a way, and man has a duty to conform his behavior to that universal order that God has imposed. And the extent to which man succeeds in conforming himself to this order, the laws are good. To the extent to which man fails to conform himself to this order, the laws are bad. Holmes abandons that in favor of a positivistic look at the law, the idea that man makes man's laws, not God, and man makes man's laws to suit himself and to suit in the collective, the community. And so Holmes, once he affects this unmooring of law from the natural law, from God, from metaphysics, and transfers it onto a purely human thing in a very Nietzschean way. With Nietzsche, man makes man's morals, man is his own God. That's very much what Holmes is doing here in a collective sense. The community makes the community's laws for its own convenience. And so once you've unmoored it, the sky's the limit. And so in that sense, within Holmes' framework, what happens with Clark v. Griswold, what happens with Roe v. Wade, these are not wrong. These are correct. These follow from Holmes's logic. This is man making laws to suit himself.
Right, and I hope that everyone in the audience can see the massive problem with this. Number one, if you accept that view, because we've actually abandoned the thing that we're supposed to be trying to conform our actions and laws towards. Or even if I remember correctly, I think there's some more atheistic versions of that are nevertheless similar in argument. There's say, natural rights view, where regardless of your view of a deity, there's a way that the law is supposed to be, and the extent to which our current legislation and the current legal system adheres to it, that is the basis on which we can say something is good or bad. Basically, everything up until this point has been trying to orient the law around something that was greater than it. But now it's the law is a tool that we can use to make the community better off for its convenience.
Leaving aside the difficulty of defining what better is once you have taken the metaphysical out of the
Sure,
picture.
yeah. I'm not trying to make an argument for it. I'm just trying to say that basically every conception of the law that I can think of before Holmes here does follow that line of reasoning, at least. This very much just seems like a social acid, if you will. Let's destroy the thing that was mooring us towards something metaphysical. It's very much about what we experience now.
And the audience can decide with 140 years of hindsight whether it is in fact a social asset, whether the community is better now for having unmoored the law from the metaphysical, or worse. Also, I want to take this opportunity to go back out to the meta point here, to the extent we may use Holmes as a totem for the Puritan strains of the American folkway. We see here this abandonment of the metaphysical, this abandonment of the natural law, this abandonment of God, well advanced in that folkway, with consequences that we will track later on in the series, but which the audience can probably guess
Right, and
at.
it's important, especially in the audience, that you recognize that we're talking about the folkway, because this is a point that we made extensively in the very first episodes of this series, is that the Puritans had a very strict belief in God, and that if you remove that, then you will you will have a system that is bad, if you will. It's unworkable. It will harm your society. This is such a system. We have taken a lot of the Puritan external forms, at least legally. There's some similar rhetoric, maybe similar reasoning and wording. It's just that the Puritans did have something metaphysical that they were bound towards. We no longer have that. We're going to veer off and see where this now unmoored folkway will take us. So, Mr. Quinn, should we continue?
Indeed, Holmes buttresses his point. What has been said will explain the failure of all theories which consider the law only from its formal side, whether they attempt to deduce the corpus from a priori postulates, or fall into the humbling error of supposing the science of the law to reside in the elegantia juris, or the logical cohesion of part with part. The truth is the law always approaching and never reaching consistency is always a, the truth is that the law always approaching and never reaching consistency. It is forever adopting new principles from life at one end, and it always retains old ones from history at the other, which have not yet been absorbed or sloughed off. It will become entirely consistent only when it ceases to grow. So here Holmes is, making the biological argument that if you're not growing, you're dying. If the law isn't constantly changing, if it's not adapting, it's dying, which is, it has persuasive power as far as it goes. But again, he's ditching this idea of law as a formal enterprise, a logical enterprise, and rather it shouldn't aim for consistency, because if it's ever consistent,
I
it's
do
dead.
find it's difficult for me personally to see the rhetorical punch of this, and I do see that allusion to natural processes. Just because I come from such a background, I suppose, where more laws is almost certainly a bad thing, or changing the laws continually just for the sake of it is almost certainly a bad thing. It is very strange for me to have to force myself to see the intended point here and make it something that's the opposite of what I would normally assume it to be. This is a
Perhaps your
what was that?
perhaps your inoculation to this rhetoric is not wholly detrimental.
Well, I mean, yeah, I think we've made the case for that, but I suppose this is my more reactionary side of things, because the groups throughout history most against just adding laws, changing laws, or whatnot else were always labeled reactionary. There are problems with just labeling yourself a pure reactionary that the online right has grappled with recently, but I think this is definitely one of its better points, and why I'm sure if anyone in the audience just read this sentence here, that the law will become entirely consistent only when it ceases to grow. I'm sure for a few of them, the negative connotation might fly past you, just because it's not as apparent to those of us outside of this philosophy that Holmes adheres to.
Well, then allow me to administer a progressive antidote to your reactionary tendencies. Again, the process which I have described has involved the attempt to follow precedents as well as to give a good reason for them. When we find that in large and important branches of law, the various grounds of policy on which the various rules have been justified are later inventions to account for what are in fact survivals from more primitive times, we have a right to reconsider the popular reasons and, taking a broader view of the field, decide anew whether those reasons are satisfactory. They may be, notwithstanding the manner of their appearance. If truth were not often suggested by error, if old implements could not be adjusted to new uses, human progress would be slow. But scrutiny and revision are justified.
It's our right. We. This is fascinating, because I think it was in late high school for me that I found the phrase the consensus theory of truth or something and thought that was absolutely idiotic. And just as I continue to go about my life, I see so many, quite frankly, terrible things grounded in this very consensus theory of what is true. And really, that's no different here. And I think that's part of why things are so bad today. This idea that we collectively can decide what is good, true, or whatnot else. That what I just said is a very basic conservative point, but once again, not one that I think should just be discarded because of the people that talk about it. Something for the audience.
Indeed. All right. Holmes continues, and this will finish us up on Lecture 1. But none of the foregoing considerations, nor the purpose of showing the materials for anthropology contained in the history of the law, are the immediate object here. My aim and purpose have been to show that the various forms of liability known to modern law spring from the common ground of revenge. In the sphere of contract, the fact will hardly be material outside the cases which have been stated in this lecture. But in the criminal law and the law of torts, it is of the first importance. It shows that they have started from a moral basis, and while law still does still and always, in a certain sense, measure legal liability by moral standards, it is nevertheless the very necessity of its nature is continuously transmuting those moral standards into external or objective ones, from which the actual guilt of the party concerned is wholly eliminated.
This is a fascinating admission towards the end here that moral standards must be transmuted into objective standards. Definitely.
Ryan, do moral standards change?
Well, me, primitive yokel, who still believes in like these natural law arguments about the law, I guess, I would have said the moral standard is objective and unchanging. But I have to remember, and this is important. I have to remember that I'm reading someone who has very explicitly disregarded that. The objective standard clearly has to be something that is observable, something that is observed. It can't be these silly ideas of metaphysics. Is that correct, Mr. Quinn?
Well, I would say no. I would say that's not correct. I would say that moral standards are eternal and unchanging, but then I share many of your reactionary priors. So maybe I am not best qualified to judge the thought of Oliver Wendell Holmes on this point. But this transmuting of moral standards is the second revolution he will attempt here. He's accomplished the first revolution by unmooring the law from anything eternal, and now the second revolution is to take morality and make it material, because an external or an objective standard is necessarily a material standard. And so we have the overthrow, not merely the unmooring of metaphysics, but the overthrow and elimination of metaphysics from law.
I will say, and granted, this Holmes is definitely much more, say, educated than I am. Probably has a higher IQ or something like that. I don't find his argument that this is all based in vengeance to be that convincing. I feel like he could have done more to actually substantiate that, other than just asserting we have these unstated preferences and whatnot else. We can infer that these primitives were concerned first and foremost with vengeance. Therefore, that is the object of the law. I feel like the argument could have been stronger.
Well, it could have been, but making that argument stronger would have weakened his larger argument, because what he's going to do with that is to then say that as civilization evolves and man attains a higher degree of enlightenment, the basis for liability moves away from the animal desire for vengeance and onto the more enlightened grounds of public policy and community expedience.
Right, and that is, I think that might be worth explicitly stating. It would be very difficult to make an absolute argument that this is the basis of the law, that vengeance is the basis of the law, without also cornering yourself into holding that up as the unchanging objective standard. So,
Surely you're not suggesting that Oliver Wendell Holmes, vaunted American jurist, set up a straw man in the first part of this lecture.
I think it's very convenient that he walked that tightrope so well that he can still not hold the thing he argued is the basis of the law as it too can be changed. That's a very convenient way out. I will put it that way.
And indeed, he will take that way out. But Ryan, I despair. I had begun the stream with the ambition of covering lectures 1 through 3 of the common law. We are now 70 minutes in, and we have managed lecture 1 and approximately 1/5 of my notes that I had prepared for this stream. So I would suggest that we have set ourselves an impossible task to do all of this in one stream, and would further suggest that maybe this is a good break point before we wade into the minutiae of criminal and tort law in perhaps some future stream.
Okay, I mean that's a good idea. We could come back to this certainly at a later date. Do we want to just talk summaries, perhaps, of
That would
what
be
was
my
left here?
suggestion, yes.
And
Why don't you give us your takeaways from Holmes's revolution thus far?
thus far, or what's coming up?
As you like.
Okay, so because this is once again, this is what's personally interesting to me, and I apologize for making that the topic of the stream, but I feel like it might be relevant, perhaps, to why we are reviewing this. Because in my, say, business law classes that I had to take, or when I was a high school student in AP US history, I distinctly remember that we get these new progressive, rational reorientations of the law, specifically because of Holmes, which is what if we made standards by which we could judge if say if someone was at fault for a specific thing. And what if we say that that standard is an ideal, abstract, perfectly rational person who had observed the action in question? And this objective standard will become the basis of the law. I did not perfectly summarize that, but I feel like that's not too
Indeed,
terribly.
you critically imperfectly summarized it, because
So,
the standard to which Holmes will reach in part 2 of this stream, in lectures 2 and 3 of his The Common Law, is not an ideal of a perfectly reasonable person, but of a reasonably reasonable person, what Holmes
yeah, right.
calls an average of the community. What would a normal, average, reasonable person think and do in a given situation? That is
Yes.
a standard he is going to construct and hold us all to in the field both of criminal law and in the field of civil law in torts.
Though I will say, with the philosophical foundation that Holmes has left us, I don't know how you could conclude anything else than that person must be the perfectly reasonable person, because that person would perfectly embody where the law should be headed, that person's opinions and thoughts on the public policy. But I'll retreat from that just slightly. This
Well, you are missing
abstract,
a critical assumption that Holmes makes, and we're kind of giving away part of the game here, but why not? Where we're going there.
sure,
Holmes assumes that the community knows what's best for it. He assumes that any random collection of human beings is perfectly positioned to determine what is in its own interests without reference to any external or metaphysical source.
right, yeah, and so this hypothetical abstract mean or average can then be used by me, the real person in the court, to hypothesize what would this person declare.
Oh, you don't get to use it. The court gets to use it against you, and heaven help you if you fail to, in the court's estimation, hold yourself to that
Well,
standard of conduct.
well, that's what I meant. Like I am the court, or at least I'm the person in the court making the decision about the law. Like I get to empathize very dearly with this abstract person, this person that doesn't actually exist. That's the summary of multiple people's thoughts, at least I think, of this group of people. And then using
Indeed.
this construct of a construct, I get to determine what the ruling should be.
You, the
which
judge, have that privilege.
is
The judge, not the jury. That's an important point Holmes will cover in Lecture 3.
yes, right, and this is fascinating to me. There's a joke that people above a certain intelligence level don't have a theory of mind for people of lower intelligence levels, but like I'm struggling to imagine that this was so the intelligence was so high in the population that Holmes was a part of that he thought that judges could derive good rulings by imagining this community and then imagining the average of the community and then further imagining what this average would decide in a given case. Uh, I'm I am struggling to like accurately try to portray that. But once again, maybe I am just dumb. This seems a little bit convoluted?
No, you're not dumb, but neither is Holmes, and he will marshal some compelling reasoning for his conclusions, but the conclusions speak for themselves after 140 years of being put into practice.
Right. So I suppose to go back to where I started all that with, I once again I'm very simple. I feel like the law either should come from something metaphysical, which despite the fact that that is has like the vibes of being locked away in some ivory tower in a university or a monastery or something. Usually when you read it, it's much simpler than it comes across. There are still problems and things to work out, obviously, but it's less convoluted than the reasonably reasonable standard. Um, and the other thing as well is that I tend to find that if you actually try to apply it, and the case in point being perhaps like the Austro-libertarians are very big on this idea of a natural law view of the law. It tends to be extremely practical, which is something I envy because if I recall correctly, where this reasonably reasonable community standard has gotten us is extremely impractical. Um, like if this, what was the phrase that you brought up earlier from the contraception case?
Emanations and penumbras.
Yes, right.
Well, emanations and penumbras, that goes to Holmes's first revolution, this idea
right.
that man makes man's laws and that we can unground them from the metaphysical. What he does with the reasonable person standard, and I guess we kind of glossed over this for the audience, but the reasonable person standard is what is used in contemporary negligence. If you do an act, the court will decide whether that act was negligent or not based on whether a reasonable person in your position would have done that act or failed to do that act. So it calls upon the court to imagine what this idealized median person, not perfectly reasonable, but average reasonable, reasonably prudent, reasonably careful. How would they behave under those circumstances? And then they decide whether you came up to that standard. That's the standard that Holmes lays the theoretical argument for in the common law at Lecture 3, and that's the standard which was adopted and which rules us to this day.
So, for instance, with the emanations and penumbras statement, it is purposefully ethereal. There is very clearly a political motivation behind it, but that's not really the thrust of my argument. There's political motivations in the law throughout history. It's just that Holmes thinks that that's like a gotcha or something to be emulated and not perhaps an accident in the philosophical term.
Yep.
But this emanations and penumbras is so purposely ethereal that if you tried to apply that to anything else than the predetermined goal that you want to get at, say by legalizing contraception under this implied idea of a right to privacy, the words of which never even are in the thing that you're looking at, you can't do that. It's concocted. This is impractical.
And to be fair to Holmes, Emanations and Penumbras was not Holmes. He was gone for
No.
20 years by the time Clark v. Griswold was decided. But it's his philosophical child, and it's the most concrete example of where Holmes's reasoning leads.
Well, I mean, we can do clear and present danger. That one's less catchy to the online right, and it's been done to death. But clear and present danger, it has the airs of being very practical. Most of us probably imagine something with images mentally when we hear clear and present danger. But the whole point is that we all imagine that, and it's going to be different and personalized. What is a clear and present danger is very impractical to determine, which is why it took until Holmes's court to force that into being something that was legally relevant. Same thing with was it the Holmes court that defined conscientious objection, or was that in the law to begin with? I'm trying to remember specifically, but you can make the exact same argument there. The standards put upon, say, what was it, the Quakers and Mennonites to avoid conscription. This is not practical. This is not something that you would derive in any other similar situation. This is we knew what we were going to do,
if you will.
Yes, right. It was very convenient. I can't fault him for being inconsistent with his focus on convenience. It's just I find this very lacking from my other prior perspectives because it is so impractical and intangible. This feels mystical.
Yeah, it's funny, in his attempts to demystify the law, he resorts to mysticism to make the argument.
Right. Or at least that's where this leads. I feel like if I look back at any other major court decisions before Holmes, like say in the antebellum period, I feel like I'm not going to find such undefined phrases as like clear and present danger. I might find rhetoric that would be employed in a similar way, but not something that would be forced upon the entire nation because it sounds good and because this is so obviously correct and reasonable.
It's good sense, Ryan. It is the good sense that is infused every stage of the development of our law.
Yeah, and it's with our good sense, why would we surrender that to a syllogism? Do you have any other comments? I feel like I'm just beating this horse to death, but that is my main takeaway from having to prepare for this stream, is that this feels very ethereal and mystical.
Yeah. As far as summing up, I'll just reiterate what Holmes did was he unanchored the common law from its ancient wellspring in metaphysical truth and the natural law. He then went on to replace this anchoring with an eternal crusade to transmute moral standards into external, objective, material standards. So fundamentally, Holmes's whole project is to turn the law into a machine, and the machine serves the convenience of the operators.
I find very few things to be more horrifying. Alrighty. Unless there's anything else, I think I can move on to ads and super chats, and I would like to return to this at a future date. This would be
I'm deeply disappointed with myself for not being more brief in the first lecture, because the second lecture and especially the third lecture is where the real fireworks are. But we don't have the time.
This is good groundwork. I think we needed to have gone over that for the next ones to make sense. So, in good time, we're all low time preference individuals here. We can wait for good things. All right. I have here before me a reminder to the audience for if you check the description, we have things that you can purchase that are within our network, shall we say. We have a link in the description, OGC specific for Alps. You should check that out. Fox and Sons coffee. We also have a link for you in the description. That is the coffee that I personally use. It works very well. It has gotten me through a lot of college, so you should definitely check them out. Axios Fitness, we have code OGC. You should check that out as well. And then the other thing that I will speak very highly of because of personal connections, Tall Men Books. You should definitely check that out. If you have need for any cool books, that is the place you should check first.
And if you desire not to be slovenly, check out MS Vendrillo and Sons. That is an excellent clothier and haberdasher who has bedecked the corpus of many an OGC man, and I cannot recommend highly enough that everyone in the audience now go immediately to MS Vendrillo and Sons and make a purchase.
Yes, yeah, that was not in my notes, but it is in the description. You should check that out. You should definitely upgrade your wardrobe if you have not already done so. That is a very clear mark that people will discriminate against you if you are slovenly, and justifiably so. So
Mm.
check out our haberdasher. For our super chats this evening, Christopher Burks 458 for $2 salutes us, and we salute you back. Thank you very much.
Salute,
And
sir.
Affix with 2 X's for $5 says, "Love you all. Make sure your friends and family know you love them too. My favorite contrarian nerds. Salute." Well, thank you very much. I will certainly be contacting my family soon. Now, this is I feel convicted. How about you, Mr. Quinn?
I too feel convicted, and I am even more convicted in my suspicion that Dawn Browning is only here for Charlie.
That's a very good point. Very conspicuous absence. I wonder if we checked this rival stream that suddenly popped up with our great co-host of this. I wonder if we would find such an account over there. But yes, thank you both of you very much for the donations this evening. Hopefully the audience enjoyed this. I enjoyed preparing for it. I thought it was a very good break from the intervention. Certainly very important. Like I said, we'll be returning to this. It is so important. Next week, if I am not mistaken, we will be covering Senator Taft's speech against us joining the North Atlantic Treaty Organization, and Henry Cabot Lodge's speech that successfully prevented us from joining the League of Nations. So continuing our non-interventionist arc that started on November 3rd with our stream with Dr. Woods, Betrayal of the American Right, we are in our penultimate stream of the post-war period. What should America have done after the wars? So this will be an important penultimate stream. Do you think it wise, Mr. Quinn, to announce what we'll be doing the week after the end of our non-intervention arc?
You know what? I have no idea what we're doing, so
Oh,
I must
perfect.
leave it to your judgment.
Okay. Well, in my judgment, I want to announce it because announcing things is fun. This is my high time preference showing, I guess. But for the audience, next week, like I said, Senator Taft and Henry Cabot Lodge's speeches against us joining foreign alliances and international organizations. And then December 22nd, 2 weeks from today, we will be finishing this arc on non-intervention by reviewing Garrett Garrett's collection of articles in the Saturday Evening Post in the collection titled Defend America First. We will
Ooh.
be looking over the actual America First movement back when it was most certainly American and America First. So that will be what we'll be reviewing December 22nd. So I'm excited. How about you, Mr. Quinn?
I am powerless in my anticipation.
Fantastic. Alrighty. Well, hopefully we'll see everyone there next week and then the week after. I'm very excited for these next 2 streams.